Hello everybody, hope you are fine and doing well. Today we will be discussing yet another topic which is very important in CPC called rejection of plaint. Now we have so far studied the pleadings, amendment of pleadings, we have come to know as to what the meaning of plaint is and the different provisions and how the plaint is to be submitted. This is what we have discussed. A very important aspect from the examination point of view which is usually asked is the rejection of plaint. See, there are certain grounds have been provided under Order 7 Rule 11 wherein if the requisite conditions are not met, the court at the outset at the very threshold can reject the plaint. Now, rejection of plaint and dismissal of suit are the two different things. Like dismissal is always made on the merit after appreciation of facts and after appreciation of the evidence, the final verdict which is given in the form of judgment, fine, or the suit when it is not decreed, then it amounts to the dismissal. Whereas the rejection of plaint is that the very outset when the certain conditions are not met or fulfilled by the plaintiff, then it could be dismissed. Now, it could be done on the applications moved by the defendant or it could be done suo motu as well by the court. So, now my dear friends, we will see as to what are those grounds on the basis of which the suit could be, the plaint could be rejected outrightly, fine. So, Order 7 Rule 11 provides that if the plaint does not disclose the cause of action. See, cause of action is a very important word which has been used in CPC at multiple time or multiple level, but it has not been defined, fine. So, it simply means that you have been stating a fact by way of a plaint to the court that this is something which has happened to you, but does this thing really entitle you to seek the remedy before the court? That is one aspect. And does the fact disclose that some damages has been caused to you which has actually led you to knock the door of the court? If these two things are satisfied, take an example. If you lended money to somebody and he promised to pay you by way of promissory note or a negotiable instrument, but despite of your repeated request he is not coming forward to settle the account, then you can go to the court of law stating the facts, sir, on such and such date I have given the money and this was the stipulated period and he was to pay back within this time, but despite of my repeated request, reminders, even the legal notice is not coming forward and he may kindly be directed and suit be decreed in my favor, fine, with regard to the recovery and all. Similarly, if you enter now here in the cause of action is what? When he flatly refused to pay the money and you have stated the fact. So, this pleading, the fact which you have narrated to the court of law now ultimately led to the cause of action. The action is to be taken on the basis of that cause, fine. So, you will mention one para in the pleading that the cause of action arose to me when he flatly refused to pay or when he served him a legal notice and this cause is still subsisting, fine. So, my dear, there is no precise definition provided under the CPC, but from the facts and from the facts which you are pleading, the court has to assess and then you need to mention one para for that, fine. So, you can see that grounds which are entitled to a plaintiff to bring a suit, that amounts to cause of action, and the fact which give rise to seek the judicial remedy, that is what you can say the cause of action is. So, if you are filing a plaint, it is not disclosing any cause of action, then court has every right to discard your complaint, reject your plaint outrightly. This is one. Second is that if you have been claiming a relief, but that has been undervalued, means you have not evaluated the subject matter properly and you have undervalued it, maybe sometime cleverly, smartly, or by way of some kind of manipulations or fabrication, or just in a haste, like you have moved in. So, court has to be very cautious that this practice should not be encouraged, and if it is found, then court would be giving the time, requisite time to correct it. But if within that time the plaintiff gets failed to do so, then court can reject the plaint. This is the second one. Third one is, if you have assessed the valuation properly, you have valued the suit properly, but sufficient stamp duty by way of court fee is not affixed. So, in that case also the court will give you a requisite time to correct it and to provide the sufficient court fee. If you still fail, then the plaint could be rejected. This is the third scenario. Fourth scenario is where the suit appears to be barred by any law. For example, you had a financial dispute where for which the remedy was say the debt recovery tribunal, or you have a dispute, you were working in a cooperative society, there is a, I mean the Cooperative Society Act provides the remedy for that, but you are, I mean, knocking the door of the civil court. So, civil court can say and send you to the right forum and discard your complaint outrightly. And if the suit is barred by limitation, obviously that would be covered under this only, fine. So, this is the fourth scenario. And the fifth is when you have not filed the plaint in a duplicate. So, I was actually really surprised when I read this provision that if the suit is not filed in duplicate, then it could be, the plaint would be rejected. But there is some cogent reason for this, like, you know, what happens is that when we file a suit, sometime we hand over the copy to the, I mean, serve the copy to the defendant that I mean, shows the different facts, and the suit which is submitted before the court, the instituted before the court, that has a set of different story. So, you know, it could happen by mistake, by chance, or it could happen intentionally also sometimes. So, in order to avoid the confusion and the precious time of the court, so that this kind of inconvenience should not cause further, then it is mandatory, fine, to file the plaint in a duplicate. Order 6 Rule 1 say so, fine. So, Order 4 Rule 1 also provide the same thing, that the every suit should be instituted in a duplicate for reason I have already stated. Now, the last but not the least, when you fail to comply with the Rule 9, where the plaintiff I mean this Order 7 Rule 9, if you fail to comply, it state when the summons, as many as defendants are there, you are provided to pay the summon along with the service fee also. If you fail to do so, then even the court can, I mean, reject the plaint outrightly at a very threshold, fine. Now, the question is whether court will extend the time for correction of the valuation or supplying of the requisite stamp papers, etc. See, unless the court is satisfied for the reason to be recorded that plaintiff was prevented by any cause of an exceptional nature, I mean the things which were beyond control of the plaintiff and due to that he could not, then the period could be extended or condoned, not otherwise at all, fine. So, as I said that earlier, dismissal of suit and rejection of plaint, there is a difference which you have to understand it. Then there is a one more pleading, I mean the plaint, when it is to be rejected, it should be rejected in a whole. It cannot be rejected in part. But Order 6 Rule 16 provides that court, if find certain, I mean, averments of the fact which are scandalous, vexatious or frivolous in nature, those could be struck down, fine. So, striking down of the pleadings is altogether different, and rejection of plaint is altogether a different aspect, fine. So, court can strike down certain I mean certain pleadings, fine, but cannot reject the suit, reject the plaint in a part. So, whenever the plaint is to be rejected, it is to be rejected in a whole. So, my dear friend, one important judgment which you need to write it down, it's last week only the Honorable Supreme Court has pronounced it, that is K. Akbar Ali versus K. Umar Khan and others. Now, only for want of cause of action, because it was not revealed, fine, the Honorable Supreme Court said, affirm the finding of the Honorable High Court and stating that yes, and it has been rightly, the plaint was rightly rejected, fine. So, these are the certain things which you have to keep in mind when the court can, like at a very threshold, reject a plaint. So, I think it is enough for today's topic, like, and yes, one last thing like I would love to clarify here is, if somebody is pleading a false cause of action, or somebody is playing a fraudulent or deceptive tactics with the court or misrepresentation or making abuse of process of court, then on these grounds the plaint cannot be rejected, because the merit of these things are to be assessed by the court after appreciating the evidence. So, only the ground which have been provided under under order 7, rule 11, A, B, C, D, E and F. Fine. So, on the basis of these grounds only the plaint could be rejected. I hope I have been able to clarify. Thank you so much.